note that this content is for adults only. It contains details of crimes against children. Viewer discretion is advised. If you haven't yet, please hit the like, subscribe, and share. Thank you. Hi everyone, welcome to today's session. We're going to talk about our first actual case analysis. So as well as talking about the kind of serious case reviews and the safeguarding side of things, I wanted to also appeal to all of the lawyers out there. So we're going to do case analyses, and today will be the first one, and it's a very recent case from April of this year. Relating to family time arrangements, or what people used to call contact arrangements, for a child who is in care. Before I go any further, if I can ask you all, if you are new here, then welcome. Please can you hit the subscribe button and give me a like if you so wish, because it really helps the channel and it's free at the end of the day. For all of those who are returning, welcome. Thank you for your continued support. Now, you'll see that I am wearing Do Not Comply, which is a piece of merch from one of my favourite creators. So it's Emma Kenny, and she has a true crime channel. She's a psychologist by trade, and I absolutely adore her. And I've just been to see her serial killer. No, I didn't. I went to see Serial Killer Next Door last year. This year, I've been to see Killer Cults on tour, and exceptional show. So if you enjoy true crime, then I'd pop on over to see Emma Kenny, and she lives literally just about 10 minutes away from me. So I kind of feel like we're kindred spirits almost. So let's talk about Re-T. I apologise for the beeping. Put my phone on silent. So this case, it was a Court of Appeal case from April of this year. And as you can see here, it's talking about contact arrangements for a child who's subject to an interim care order. So when a child is first removed from their family, whilst the court proceedings are ongoing, they can be removed, and that removal maintained under an interim care order. And that's while the court decides what to do in the long term with this child, and what's the best place for them. Now, what I will say, because this is a very common misconception, and I've dealt with lots of cases, in particular some quite recent, where parents have been of the opinion and have widely publicised their view that their children have been either stolen or trafficked, or, you know, that the local authority are in it for some kind of monetary gain. The reality is, to keep a child in local authority care costs an absolute small fortune per child every year. And so there is no monetary gain for anybody. And social workers in particular, who often get a lot of flack, do not get paid very much. So they're on kind of similar concepts in terms of pay to nurses and the like. For what they do, they are dramatically underpaid. And the key aim of any social work intervention, albeit parents don't often believe this, it is absolutely true. From my years working within this industry, this is something that I can absolutely attest to. The key aim is, wherever possible, to keep a child with their birth family, whether that be the parents or the wider family, but to keep the child in their birth family. with support, and sometimes those support packages are absolutely, you know, phenomenal. They are quite wide ranging, but equally, sometimes it doesn't matter what support package you put in place, it is simply not enough. So when a child is removed and we've got care proceedings that are ongoing, what happens in terms of contact? Well, the local authority got a duty to make sure that they promote family time with the child's family, that being their parents, any full-time carers, and also any kind of family members who they've got a really strong link to. And this particular case was an original decision by his Honour Judge Greensmith, and that appeal was from a decision by him at the Liverpool Family Court. And it was heard by 3 appeal judges, Lady Justice King, Lady Justice Nicola Davies, and Mr. Justice Cobb. And, well, what was it all about? And I think, first of all, let's look at who was involved in it. So the person who brought the appeal was the local authority, Liverpool Council. They were represented by Simon Heaney. Mum was the respondent parent, and she was represented by 2 barristers, Kate Bonnell Casey, so that's King's Counsel, used to be QC, Queen's Counsel, and Joanna Mallon. And then the second respondent is actually the child. So the child is always a party to these proceedings, but they act by their children's guardian. So what was the background to this case? It involves a young girl who was 3.5 years old. She's only referred to as T. So in the United Kingdom, where any proceedings involve a child, they are kept anonymous. So any judgments, all of the parties will be anonymised in the paperwork that gets released. And it's not the same as in the USA. So after proceedings have taken place or after certain stages, we don't get a release of all of the material relating to the particular case. We get the judgments, and that's pretty much it, really. So girl T is 3.5 years old. We don't know the whereabouts of her dad, and he's not involved in the proceedings, but we do know, obviously, who Mum is. And T, until these proceedings started, lived with Mum. Mr. A was Mum's previous boyfriend or partner, and he had previously resided in the family home, but he wasn't at the time that the child was removed. On the 1st of January of this year, Mum went to the police and she made an allegation that 20 months prior, so that's around May 2022, when T was less than 2 years old, that she had been essayed Mr. A. Now, to rely on evidence, she showed them an explicit photograph of the abuse on her mobile phone. And the police's response was, well, can we have a look at your phone, please? But bear in mind, if it's Mum's partner, they'll want to understand what she knew and when she knew it about what was going on. So they had a look at Mum's phone, which she gave over willingly. And what they found was another photograph that had been taken minutes before the one that she relied on, which implicated her in the abuse. And they also found incriminating text messages between Mum and Mr. A. So what happened? Well, the answer is both of them were arrested, and they were charged with a variety of offences. I'll come on to in a minute exactly what those were. And they were remanded in custody. Now, on the 10th of January, so we're talking, not very many days after she was initially arrested, Mum was released on conditional bail. And one of those conditions was not to have contact with T, the child, save as ordered by the family court. So the criminal court's gone, if this were any other assault case, I would say you can have bail, but you're not to contact the victim. But then they know that there's likely to be proceedings in the family court that run alongside of these. So what they said was, well, we're going to give you conditional bail. We're going to say that you shouldn't contact T, but then we're also going to push it back into the family court arena. So they've got to make the decision because we don't want to, which is fine. And there is often kind of an interplay between the two courts, not just in these types of cases, but where you've got juveniles who might also have ongoing proceedings that are arrested for offences as well. So the charges were that under Section 7 of the Sexual Offences Act 2003, they both SA'd a child under 13, namely T. They took a photograph or pseudo-photograph of T that was indecent under Section 1(1)(a) of and Section 6 of the Protection of Children Act. And then the last one is possession of that indecent photograph. Mr. A pleaded guilty to all of the charges, but the court didn't sentence him at that point because Mum did not plead guilty. Mum pled not guilty. So they've set a trial for her. The trial date is for later on during the summer of this year. And what they've said is Mr. A will be sentenced after her trial. Bear with me again. Now then, you've got to ask the question, what happened to T after this? So Mum gets arrested, she's carted off, and then this child is there with nobody to look after it. And what they initially did was the police placed T with maternal grandma, so Mum's mother. But once children's social care got involved, they realised that T had lived with her maternal great aunt, so Mum's aunt, basically, for about a year between summer 2021 and summer 2022. Completely unrelated to this issue, by the way. And so they moved T to live with this maternal great aunt. Initially, that was under agreement, which is called a Section 20 agreement. So under Section 20 of the Children Act 1989, a parent or guardian can agree to a child being placed into local authority care. As a side note, a child can also agree once they reach the age of 16, so you wouldn't need a parent's agreement at that point. So 1st of January, Mum gets arrested, goes to maternal grandma, then we go to great aunts under Section 20. Now then there's a court hearing on the 27th of February. And in that court hearing, an interim care order was made. So that then becomes the framework under which this child is living with maternal great aunt. one of the big questions was, what do we do about family time between mum and T, bearing in mind that there are allegations of serious SA of a child of under 2 years. And generally speaking, whatever allegations are made, no matter what we're talking about, SA, domestic violence, whatever it might be, what's reported is the tip of the iceberg. And so social workers always have that in mind when they're trying to make decisions. Now, during the hearing, well, first of all, between the 1st of January and the 27th of February, there was no contact whatsoever because there was a bail condition in relation to one court, and the family court hadn't yet actually had a hearing. So there couldn't be any contact during that period. So there was 6 weeks when T didn't see her mum. Then on the 27th of February at this case management hearing, an interim care order was made, and mum agreed to that on the basis that she knew the allegations need to be investigated. And the judge, during the first part of the hearing, made a very clear indication that family time should happen and it should be in person. And so the parties left the courtroom and they sat down and they came to an agreement based on the judge's indication of a roadmap for how contact was going to play out. And it was put into the recitals of an order, and I'll talk about what that is in a minute. But what they agreed was that there should be direct face-to-face contact 3 times a week that's professionally supervised. So a social worker or someone akin to that would supervise, to be in the room the whole time. And the local authority agreed to do some direct work with the child on the 4th of March. That would be kind of preparing her to see mum. That there would then be a supervised video call on the 6th of March. Then on the 8th of March, the first direct face-to-face contact would take place. And then there would be 3 times a week from there on in. And the court said, yeah, I endorse that plan. Now, the court also said, because you've come to an agreement, it doesn't need to be an actual order. It can just go in what are called the recital 2, which is basically a bit of blurb at the beginning. It's a bit of fluff that talks about kind of important background information. There are house rules about what should go in orders and where in the order that it should go, and that becomes relevant later on. But a recital is not an enforceable order. So the judge cannot, in theory, later say, you've not complied with an order, and penalise you in any way for that. Now, what happened after that hearing was that the preparatory work was done. So the direct work session with the child and the social worker took place, and that went fine. And then on the 6th of March, so 2 days after the direct work session, the video call took place. That was supposed to be the one and only video call, and it did not go well. Let's say that was definitely the case. T was scared. She was tearful. She was resistant to seeing her mum. She asked repeatedly for the session to end. And after it did end, she was really upset. So the foster carer said, the maternal aunt said she was really distressed afterwards. And the social worker who was there said she was really distressed afterward. So the local authority were in a bit of a predicament because they'd made this agreement about what to do, not taking into account or not knowing that this young child was going to react so badly to seeing a mum. So what they decided to do was some further video calls. That makes sense, doesn't it? So you give the child more time to get used to the idea of seeing a parent who they may perceive as scary because of what's happened to them. So there were 2 further video calls, one on the 12th of March, one on the 19th of March. Now, at the first of those 2 sessions, T referred to her mum as naughty. And during the session, she also called her a monster and a dinosaur. And afterwards, again, she was very visibly distressed. And then the second of those, so that's the 3rd one overall, on the 19th of March, again, it didn't go hugely well. And then afterwards, T was very visibly distressed. Now, it was coming up to another court hearing. And at that hearing, the 2 parties, the local authority and the mum, disagreed really about how those sessions had gone, or how those video calls had gone. So the local authority said that all of the sessions were difficult and that T had been resistant and unhappy about seeing or engaging with her mum. The mum said, look, over the 3 contact sessions, actually things really improved, and by the last one, she was upset when it was ending, because it was ending, not because she was upset by me. What did the court say? Well, before the hearing, the local authority made an application using the right paperwork to restrict the contact to just video calls once a week, with a view to moving towards direct contact once T was ready for it. And that's under section 34(4) of the Children Act of 1989. And really what this is for is it allows a local authority to seek permission to refuse to promote family time. So it's a permissive order. It doesn't mean that you have to, on every occasion, refuse to promote that contact, but it allows you to step back if you need to. That being said, it is supposed to be for refusing contact as opposed to just restricting it. So in theory, the reason that the courts try and steer clear of making orders about what contact should take place is that's something that is very much within the professional realm of the social worker making an assessment about what is appropriate in those circumstances. So it's the ruling is you've got to promote reasonable contact between the child and their parent. Well, what's reasonable? What's reasonable is something that is in the child's best interests. So if a particular type of contact isn't within the child's best interest, then really the local authority should be in a position to say, actually, no, this isn't how we're going to do things for the time being. We're going to do X, not Y. Sometimes courts do make orders for specific contact. It became very popular during the time of COVID lockdown because local authorities were trying to very much limit the amount of contact that was happening because they were trying to protect everybody involved, essentially, particularly where supervised contact was taking place, because the professional who's having to supervise the contact is having to be close to the child, to the parents. Got parents from one household and children from another household coming together. So there was a lot of risks there around that period. And the family court were quite clear that, we still had to ensure that the contact was in the best interest of the child. And if that meant seeing the parents more than once a week, then we had to do that. And that's fine. But generally speaking, the court try and stay clear of it, and that's the reason why. The local authorities' view at this time was rushing to start direct contact would very likely have an adverse impact on T. And that makes sense, really, doesn't it? If you have been abused, essayed, or suffered any kind of other behaviour by a perpetrator towards you that is scary as a child, and then you're taken to a place of safety, if you're then put back in a position where you're in the same environment as the perpetrator, it's going to re-traumatise you because it immediately all comes flooding back. A lot of these children have got PTSD of one form or another, and seeing the parent can be a trigger. You've also got the fact that they may be just genuinely scared that they're going to be the subject of another piece of upsetting behaviour whilst they're in the contact session. Also, they don't know if they're going home with the mum or if they've just been taken to see them and then they're going to go back to the place of safety. Even though that's explained to a child beforehand, they don't often completely understand that concept. So it's still scary for them. So the local authority were really clear. Direct contact shouldn't go ahead at this point. With the application, they filed a statement that was headed "Statement in Support of Application" under Section 34(4) of the Children Act. So the judge, on the face of it, seeing that statement, knows that's what it's about. And in that, they said that T doesn't want to have face-to-face family time with the mum. T had made additional comments to the police that caused concern and were being investigated. So when allegations like this are made, the police do something called an ABE interview, an Achieving Best Evidence interview. So the police do an Achieving Best Evidence interview, and what that is, it's a very specialised type of interview session where they will sit down with a child in a room that's very much like a living room, so it's a cosy space, and they have very highly trained specialist police officers who do these interviews, and they will play games with the child, they will do drawings with them, all in order to try and extract information from them. And the whole time they're talking to them, it's more like a conversation. But they do make sure that they establish at the beginning that the child knows what telling the truth is, what telling a lie is, and generally the concept of the difference between right and wrong. Once they've done that, then they move into this more kind of conversational approach. And they are videoed from different angles, and there is also recording equipment in there so that they pick up the audio really well. Now, I'm assuming that this comment has come during one of those interviews with this child. And sometimes it takes a few, because they have to have kind of rapport building sessions with the child to get them to feel safe enough to open up about what's happened to them. And you can imagine trying to extract information about this kind of topic from a 3.5-year-old would be hugely challenging. The police absolutely have their work cut out for them, but they are very highly trained in how to do that. So T had made some extra comments, and the police had moved on to investigating those. So we're starting to get an understanding that this is a bigger picture. This isn't a single isolated incident of FA that happened 20 months ago. This is something wider. And in the statement, the social worker makes it clear that, assuming, as we have to when we're looking at things from the perspective of how is contact or family time going to work for a child in this situation, that the SA did occur as alleged, then seeing one of the perpetrators could make them very scared and re-traumatise them. We've just spoken about that. It makes complete sense. Now, during one of the very last video, Mum had asked T outright, well, do you want to see me in person? Which is completely inappropriate, and she will have been warned beforehand not to discuss it with the child, because you're not going to get a proper answer from a child when the parent asks. How many children agree to all sorts of things because they think it will make their parent happy? That is what children are hardwired to do, try and make you as the parent happy. Try and keep their environment as safe as it possibly can by making sure that you are, as the parent, happy. You're not angry with them, you're not upset with them, you're not ashamed of them, you're not, any of these things that the average parent doesn't feel about their children. But even though children of those parents sometimes think that they might, or they do. So for a child in this particular situation, they're going to say what they think their mother wants to hear. So the social worker went through the fact that that had happened and that it was inappropriate. What's the parent going to say to them during a contact session directly, face-to-face, when they can whisper to the child where the supervisor can't hear, that type of thing. And the recommendation by the social worker at that point, the suggestion, the recommendation of the social worker, and that was that there should be 6 weeks of direct work to establish what T's wishes and feelings were. Now, in court, the local authority solicitor also submitted a legal framework document, and that stated that there were serious criminal charges faced by the mother and accepted by Mr. A. So we've got a good indication that chances are this stuff did happen, that go to the heart of the physical, emotional and psychological well-being of T. Not just now, but also in the midterm and throughout her life. So if we get things wrong now about family time, that could have a marked impact on her all the way into adulthood. These are really important decisions that are being taken. So the conclusion was that the document urged the court not to default to there's got to be direct contact, but to look at whether that's in the best interests of T. And in reality, that's what should always happen. But what did happen? Because that isn't what happened in this case. So the case management hearing happened on the 22nd of March, and it was largely dedicated to the issue of family time. And the parties' positions at that hearing were that the local authority recommended video calls once a week with this 6-week period of trying to ascertain T's wishes and feelings. So that is a phrase, wishes and feelings, that is coined and used right across family proceedings. And the court has to have regard to them, taking into account the child's age at the time. Mum's position was that there should be 2 video calls a week. So she agreed initially in pre-hearing discussions that it should be just video calls at this point. But then during the hearing, based on the things that the judge was saying through the hearing, she changed her position to she wants direct family time to start immediately. The children's guardian, on behalf of the child, agreed with the local authority there should be 1 video call a week in this period where we try and establish what the views, what the wishes and feelings are of the child. What did the judge say? Well, he said that an order for contact was made on the 27th of February, which isn't accurate because it was laid out in the recitals, so it wasn't an actual order. That the local authorities should have made an application to the court if they couldn't comply. Well, again, that boils down to, was it actually an enforceable order as to whether or not the local authority should have made that application. But regardless of that, they had made an application under section 34.4, and the judge didn't seem to be aware of it, despite the fact that he'd read the statement in support of that application. So he'd made reference to that, and it was headed statement in support of section 34.4 application. So when he read that, he should have thought, I think there should be an application to go with that. I better have a look. And for family proceedings, we have this thing called the court portal, where all documents are uploaded, and the judge has got access to that. And that is where we would upload, for example, a draft order once it's drafted by the person who gets identified as responsible for that in the hearing, normally the local authority's representative. And the court then approves it and seals it as a formal court order, or comes back and says, no, such a thing is wrong, you need to change it. But he didn't go away and have a look for this application. He just went off on his merry way, assuming that there wasn't one. He also said that the local authority shouldn't take the word of a very young child, and it was the second time that day that the local authority had attempted to rely on such, and that there was no significant change that had occurred in T's circumstances since the original order for contact on the 27th of February was made. And he went on to say there needs to be direct contact 2 times a week, so he changed the frequency, starting no later than the 2nd of April, so a couple of weeks after the hearing. He also went on to say, and of course that contact should be heavily and closely supervised, and that whilst the child may have demonstrated some distress, we weren't at the point where the distress was at a level that he could refuse to agree to direct contact. He did invite the local authority to bring the matter back to the court if they felt that they had reached that point and that the child was too distressed and her best interests meant that there shouldn't be any contact. So he kind of, at the very end, he almost pedalled back on himself, but didn't quite. So he still went ahead and made the order. Unfortunately, what happened was they were again put in the recitals, and not only were they put in the recitals, but the judge sealed that order with them in the recitals, so they still weren't a valid, enforceable order. But the local authority felt that they had been pushed into a corner, and so they made an appeal to try and have that decision about family time needed to be direct overturned. And at the beginning of their judgment, the appeal court set out what the statutory framework is that they're working under, which is the Children Act of 1989, Schedule 2, paragraph 15, and I've set out here kind of what it says, which is, we've already talked about this, the local authority will promote a reasonable contact level of contact between the child and his parents. Any person who is an adopted parent, so I've got no idea how I managed to time that, or that has parental responsibility, and any relative or other person connected with the child that's got a good relationship with them. That's got to be reasonably practicable and consistent with the child's welfare. Now, it talks about a looked after child. What is one of those? A looked after child is a person who is in the care of the local authority, either by virtue of a care order, that can be an interim care order or a final care order, or a Section 20 agreement, which is an agreement by the parent or the child if he's over 16 to the child being in local authority care. And then the other element of the statutory framework that the court were looking at was Section 34 of the Children Act. So I've set that out here, and I'll go through it really quickly. So the local authority is under a duty to allow the child reasonable contact with his parents. That's Section 34(1) of the Children Act. The local authority, child or parent may apply to the court for orders regulating contact, whereupon the court may make such order as it considers appropriate with respect to contact which is to be allowed between the child and any named person. When making such an order, the child's welfare is paramount. The court must have regard to the welfare checklist, which is Section 1(3) of the Children Act, and that is basically the checklist that overarches everything the family court does in relation to a child. So they should always have regard to that when they're making decisions, generally speaking. The court must not make an order unless it would be better for the child than making no order at all. The local authority may make an application for permission to refuse to allow contact between the child and any person. And when making an interim care order, the court may make a contact order even if nobody's applied for one. So the court can just decide that it needs to include contact order in with the interim care order. The local authority have got a power to refuse to allow contact for up to 7 days, where it would otherwise be required if it's satisfied that it is necessary to do so in order to safeguard or promote the child's welfare. So if you're in a situation where you can't immediately get to court, there's going to be a contact session or a family time session, but you don't think it's in the best interest of that child to attend it, you can refuse to allow the child to go. And that's for a period of 7 days. So sometimes we can't get a listing before the court that quickly. Hence the reason for this kind of period where the local authority can make the decision of their own volition. The judgment itself by the appeal court included kind of a discussion as well, and they talked about the fact that the judge in this case treated it as a case of non-compliance by the local authority with an enforceable order, rather than, as it probably should, see it as a reason to pause and reflect on whether the arrangement met T's needs, and that the judge's decision was to a significant degree contaminated by his view that the local authority had failed to comply with this order, with his original order. They also concluded, and this is the very important bit, that the decision was fundamentally flawed and that there was a significant change at the time of the order, the second order being made. And that was this, that at the time of the order on the 27th of February, T hadn't seen her mum for 6 weeks. And in the intervening period, when she was able to see her mum by video, on 3 occasions, there was the professional assessment that she was distressed because of it. So that is a significant change. So the judge in saying that there was not a significant change was incorrect. They also concluded that the judge was inherently contradictory of himself. So on one hand, he said, we've not got to the stage where T's distress is at such a level that we can look at refusing contact. Then went on to say, but we need to get to the bottom of her distress. And then went on again later on to say, it's clear that the social worker took, put in a lot of effort to achieve family time with a child who was very distressed. So he talks about her not being distressed enough to consider things, then talking about needing to get to the bottom of her distress, and then talking about her being very distressed. So he doesn't keep kind of the same view of how distressed she was during the judgment. And this is what I was talking about with he almost pedalled back on himself, but not quite far enough. And they went on to say that the proposal for close, heavy and professional supervision of family time didn't take into account that the risk that the social worker was talking about was emotional harm from seeing the perpetrator. It wasn't, they couldn't stop further SA happening right in front of them, because they probably can. But it's the emotional impact of seeing the perpetrator. And the fact that he suggested that the social worker restore the matter to court if they formed the view that T was suffering adverse harm was incorrect, because that's exactly what the social worker was saying at that time and had set out in writing in her statement in support of their application. They went on to conclude that there was no meaningful consideration of T's welfare. that there was no reasoned analysis of the harm or risk of harm if direct family time were to take place, that it was a mistaken belief that the local authority had based their unwillingness to advance direct family time on the word of a very young child. They'd actually based it on their observations of what the child was like during the family time and their professional analysis of that presentation by the child. The judge was premature at best in his decision, that he did not consider T's circumstances individually and had paid little attention to T's emotional needs during his judgment, and that he didn't address the mother's capability of meeting T's needs during a direct family time. And that was on the basis that there was some indications in the reports from the supervised video calls that would suggest she might not be able to. And the judge failed to give weight to the allegations of SA as clear indications that the child might be traumatized by having to attend direct family time. There was no indication in the body of the ruling that treated T's welfare as preeminent, the most important thing. And the decision that the local authority must facilitate interim direct family time was wrong and cannot stand being harassed by the dog. I shall try to ignore her. It was not necessary to determine if it was wrong to elevate the recital to a status of enforceable order because the rest of the judgment was fatally flawed, but they did go on to sort of address it. So they looked at 3 cases, BSA and NVT in 2020, X and Y in 2019, and H and H in 1993. And they concluded that there was no authority that was put before them that convinced them that the court should regard recitals as enforceable orders. Moreover, in the orders in this case, there were a disproportionately high number of, in their words, highly discursive recitals that made the orders unwieldy and difficult to navigate. And that the orders themselves offended against the President's memorandum on drafting orders in November 2021. So there is a President of the Family Court. He often will provide guidance for the judges. One of them was this drafting orders memorandum. There were also house rules which supported standard family orders that had been circulated in May of 2023. Now, they were circulated in a slightly amended format to how they'd been previously, but actually the bit that we're talking about didn't particularly change. The House Rules extract, I'll read to you because it's important. So, recitals in a children's order shall appear at the end of the order. Recitals must only record necessary information, drafted in as short and neutral as possible a manner. They should not record what happened in the hearing. They should be limited to essential background matters, which are not part of the body of the order. And any purported views of the court or the parties, which do not form part of the court's decision, should not be recited. And the recordings of any party's position before, during or after the hearing, as a recital should cease. Now, I've got the actual template draft order, case management hearing order, which I've just taken the first couple of pages of to demonstrate to you what they're talking about. So let me see if I can zoom in. I've got no idea how you do that, which is awesome. So what I'll do is this, I'll talk you through it. So you have kind of the heading of which court it's in, what the case number is, then you have the name of the children and their date of birth, and then you have who the parties are and who they're represented by. Then there is a confidentiality clause and some warnings about basically not disclosing any information that might identify any of the parties, in particular the children. And then there are some declarations. That's what part of what we're talking about here. And then it goes on to talk about what the court actually ordered. So this first bit that we're talking about, this is kind of what they're talking about, recitals at the beginning of the hearing. What was talked about in relation to contact should be in the actual order section. And then at the very end, there is a schedule, and it includes information such as where the child is placed, what the contact arrangements currently are, what the timetable of the proceedings is, what the threshold contains, so what the key issues in the case are. And it can include, if it's a remote hearing, some information about how long the hearing took to make sure that the legally aided parties' representatives can get paid. So the court hadn't even made an enforceable order in the first place. The appeal went on to talk about one final point, and that is the judge had adjourned the section 34.4 application and said we'll look at that as and when it gets to the point that it's relevant. And the court said that wasn't, the appeal court said that wasn't wrong, in fact. That was one bit of his judgment that was correct. And the reason is that the local authority only wanted to restrict contact. They didn't want to stop it. And so they should have issued an application under section 34.2, not 34.4. So because the local authority plan wasn't to fully refuse contact at that point, it would have been premature to accede to the application if he did so. And for that, they looked at the case of Ries in 2005. So that's the case of Ries. What does it tell us? Well, it tells us if you're going to make an order, it's got to be part of the actual order section of the final order that's submitted to the court and sealed by the court. A recital is not an enforceable order. But it also tells us, more importantly, that you've got to look at every child's welfare based on its own facts and the individual circumstances of that child and what's happened to them when you're deciding what is the most appropriate family time arrangement to have during proceedings. That's the key part. And not only do you need to do that, but you need to record it in your judgment. You need to establish what your view was about the child's welfare, and you need to look at the welfare checklist when you're doing it. So as a judge, that's what the Court of Appeal is saying you need to do when you're looking at arguments about family time during proceedings. I hope that that has been interesting, even for those of you who are lawyers, and that the lawyers have found it a useful update as well. I've gone into a bit more detail about the basics because I want these case analyses to be interesting for everybody, so people can pick up a bit of information about family proceedings at the same time as lawyers getting good case law updates. And on that note, ladies and gentlemen, I am going to leave you to your evening or morning or whatever time of day you're watching this. And I'm going to go and have some tea. So thank you very much for joining me. Shameless plug again, please can you subscribe and hit the like button. And if you're feeling really kind, share the video so that it gets seen by more people. And I will see you next time. Look after yourselves. Please note that this content is for adults only. It contains details of crimes against children. Viewer discretion is advised. If you haven't yet, please hit the like, subscribe, and share. Thank you.